Okay, so thank you very much, everyone. I'm happy to meet everyone again, and I know that it has been. I've looked at your timetable. You have attended a lot already. Okay, so I'm not sure whether many of us here in this session are familiar with this area of law. Okay, so we're going to talk about international investment law. So when I conduct my classes on international investment law, I would first of all ask them what is the perception of the topic. So well, some of them would give me an answer that it sounds technical. It sounds a little bit of calculation, something like that. But basically, we are still talking about within the perceptions of international law. It is actually a very interesting area to look at. And it really opens up our dimension, our horizon of thinking, and looking at what we have around here every day is actually, they do not result out of nowhere. Okay, it has some direction on the evolution of international investment law. And first of all, when I see the theme of this ACL today, okay, the theme is reimagining borders. I think it's very a catchy word, and very much make us realize that we are living in a constant changing world. Okay, and the mindset of us is to see that things are changing, and therefore we have to adapt, and the law has to follow, to suit what functions the law can play. All right. So in the context of international investment law, it is the law, the function of law is to enable international cooperation. And then, okay, so the topic of international investment law, it is a field of international law. People would say that it is a rather relatively new area of international law, okay, because it's not strictly traditional under public international law and not strictly traditional under private international law. It is a hybrid area which combines both elements. We will see later on, but basically what this law means is it evolves from treaties, okay, signed by states signed into treaties. Well, basically for states to guarantee certain protections for foreign investors. So we know that according to the history, we know that states, they need foreign investments for the country. And in order to attract investors to come in, when states enter into treaties guaranteeing certain protections, then it would allow a more investment-friendly climate, okay, for foreign investors to come in. So that is basically the main idea. It's about treaties signed by states, okay, to allow foreign investors to come in. Okay, so I will go on to the next slide. Okay, well, basically in this slide, we will see the hybrid nature of international investment law. So we know when we talk about public international law, we are talking about states, okay, against states' relation with other states, okay, in many aspects of international cooperation, of issues relating to general humankind issues relating to states, okay, which includes, which you have learned probably here, law of the sea, okay, international criminal law, environment, maybe humanitarian law. So those are the issues under public international law. And then we know that there is no superior law because every state is sovereign. And therefore what binds them together is that they sign into treaties and conventions which oblige themselves for obligations. Okay, so the next area of law is private international law, where basically it involves citizens against citizens of another country. And the types of disputes are disputes which have some foreign elements in it. Okay, so it can be issues of marriage, it can be, but many situations they are involving commercial agreements or commercial disputes between foreign people. And what binds them together, again, as well, okay, agreements between each other. But international investment law, we say it is a hybrid of both public international law and private international law, because when we talk about who is it involving? It's not, it is between state and state, or during the signing of the Treaty of Protection, but the benefit goes to the foreign investors. So when states oblige themselves to protect foreign investors, if the state breach in providing those protection, the investor can bring a case or can bring the state to arbitration. So that is what makes it different. So this, by international investment law, it is actually the first time where you allow an investor to summon or to sue, not to summon, to bring a claim in an arbitral tribunal against another state. So investor against state. So this is because we have the ISDS clause, we call it the investor state dispute settlement clause in treaties, in investment treaties. And then what is it relating to? It is relating to disputes on foreign direct investment protection. So as long as you can illustrate that you are having an investment where you have capital in it, okay, some signs of ownership in it, okay, so you can, if the state has introduced any measures which affect your investment, so that would be a subject matter of the dispute. And then you have international investment agreements to allow this to happen. This is the enabling treaty. Okay, I invite you, if you have any questions to ask, you just raise up your hands and I will try to address that when we go, okay? Right, so to give you some idea on how huge the area of law is, of international investment law, well, this one involves the whole globe, okay? In the span of only 50 plus years, you can already see by the year 2019, okay, the total international investment agreements is 3,284. You can imagine that, that's a lot, okay? Malaysia, we already have, I think, 100 plus investment treaties with many countries. You have one with Thailand, we have one with Jordan, we have one with Saudi, or almost all of the countries in the globe. I believe Indonesia as well have that amount of investment treaties. And then not mentioning bilateral investment treaties, sometimes we also have groups like regional investment treaties, okay? For example, you have, in the past, we have CAFTA, CETA, and etc. And then also to show you how this area has been, is very big. You can see around the globe, there are many investment arbitral institutions. So what do we mean by these arbitral institutions? It means that if you have any dispute, you can just go to these institutions for them to help you, to assist you to organize an arbitral tribunal. So you know, when we're talking about arbitration, you can choose your arbitrator, okay? You have a say in the law. So basically you will be using the law of, depending on the agreement, okay? So, well, there is more autonomy in arbitration, and that is, that can be happen. Why? Because we can choose many arbitral institutions, and by that you are also actually choosing the rule that you want to be abide with, okay? So sometimes you use UNCITRAL rule, okay? Sometimes if you want to go in Malaysia Arbitration Center, AIAC, you can use the AIAC rule. If you want to go to London, you use the LCIA rule, okay? If you want to go under ICSID for investment convention, settlement of investment dispute, you can use under ICSID rule, etc., etc. Okay? All right. So we cannot run away from the history. If you learn law, you can't run away, especially when you learn international law. You will have to know the political economy of the world, at least for a couple of 100 years back. Okay, for you to gain a view or to appreciate the whole story of how the evolution of international investment law took place. So this is basically very much a little bit of a Eurocentric version of the evolution. The West says that the concept of sovereignty rose in the Peace of Westphalia, 1648. That very much ended many years of war of many parties. We had that time Spain, Dutch, and also Germany were in constant war. So when they ended this war, basically they had relative peace during that time, by Treaty of Münster. And one of the element in their Peace of Westphalia is they had treaty protection of foreign property. So in war, normally the practice was the warring party will confiscate or will take foreign properties. That is what they do not want. Okay? They do not want to stop that from happening, and that was one of the elements in the Peace of Westphalia. Where we look at our archipelago during this time, where were we? So where were we at that time? Well, in the Kesultanan Melayu Melaka, we had already government around here. Many sultans, kings, even in the Indonesian region. Okay, and then by 1511, in Malaysia, in Malaya, Tanah Melayu, we had the invasion of the Portuguese came, and then the Dutch came, and etc. That is basically what we had during that time. And then also at the Middle East, the Ottoman Empire was basically in operation in that time, and the Ottoman Empire was neutral, basically took the approach of neutrality, not to interfere in the war during that early time of modern time. Okay, but we also know in the beginning of the First World War, the Ottoman Empire took part, and that was what led to its demise after World War I. Okay, so alien property was commonly seized after the war, and the seizure of foreign property was a symbol, okay, to weaken the enemy. Not only effective to weaken the enemy, it is also a symbol of humiliation, okay, a security for debts, and also as punishment. All right, so there's a picture down there which I show you, which I put here. It is what we call a gunboat diplomacy. During the olden time, if foreign investors' property were abused or were taken by the country, then the host state, okay, the foreign investors' home state will come and bring their boats at the shore, okay, to show their power and to attack the country, sort of like punishing them why they have abused their nationals. Okay. All right, and then we also know the emergence of investment law was basically also because of the past need of the countries around the world. Again, when we're talking about the Western history, it was because of the Industrial Revolution. We know why the imperialists came to many parts of the world. That was because they needed raw materials, and because they had this technology of steamships, which basically enabled steamships to carry lots of stuffs, and also enhanced transportation at that time with steam engine, etc. And also at that time, the emergence of global economy from 1820 and just before World War I was also because of the end of Napoleonic Wars. Okay, again, relative peace and boost international economy. So you couldn't imagine at the time business flourished very well, okay, before 1914, and that was because of the international cooperation that they had during that time. This is in the Western context, okay, and also what enabled that was the economic theory or liberal economic theory, okay, by Adam Smith in his Wealth of Nations. If you read that, this is a very an old book, okay, which encouraged free competitive markets. So it basically says that if you cooperate, you can just purchase whatever other people can do effectively. So you don't have to produce everything. So it's basically an idea towards liberalization, okay, in order to move freely and also do business freely among countries. All right, so the United States of America, during that time as well, they already had their Friendship, Commerce and Navigation. They call it as the FCN. So many agreements during that time to allow free trade. Okay, so they call this as FCN. And among the important elements of the FCN is that it includes principles of access, non-discrimination, and due process.